Everyone. Welcome to the fourth Salon in the Transnational Justice Project Critical International Law Salon series. Our theme for today is going to be the complexities of victimhood. This conversation we're going to have today and more or less about the series that we had in three different salons, more broadly engaged with the themes that will be explored in the inaugural Transnational Justice Project Summer School, which is going to be held in Rwanda between July 18 and July 23rd, 2022, later in summer. And this summer school, for those that might be wondering, is open to advanced students in the social sciences and law, and brings together faculties from academic institutions around the world to engage, to debate, and collaborate on topics related to critical international law. And this is something that everybody's talking about, international law, the relevance of international law in light of global event in Europe and other parts of the world. For today's Salon, our conversation is going to engage on the category of the concept victim, which we all know is central to a notion of crime, as that of the perpetrators of crime. You know, the concept of perpetrator is something that's all over our vocabulary as international law scholars or anthropologists or in whatever field of endeavor that we are that intersect with international criminal law. And over the past 2 decades, the roles of victim has grown in importance, particularly in the prosecution of international crime, whether the ICC, the ICTR, ICTY, the Special Court for Sierra Leone, in any ad hoc tribunal, the roles of victims is, has evolved and has become very non-pronounced with ICC. However, as part of the contemporary theaters of justice, more attention has been paid to the category of perpetrators, even in the popular media and discuss. The word is all about perpetrators of heinous crime, perpetrators of genocide, and so on and so forth. And the victims has been more or less, if you look at it historically, has been in the margins. Who is a victim? How do you construct a victim? How do you define a victim? How do you categorize a victim? And to understand in some case the collective nature and complexity of those that this victim suffers, or that has not been centralized well with ICC. It's been centralized, but still there's need for more knowledge in that area. So this panel today, this our distinguished and august panel, we engage with the evolving and complex ways of understanding and the category of victimhood, while also in their discussion also reflecting on other alternative modes for conceptualizing the nature of harm and forms of social restitutions that are possible and are available to victims of different heinous crime across the globe. But before we dive into the conversation, I would like to do some few logistics and then introduce our panelists, and then we get into the meat of the discussion. The format today is going to be one which our guests, our panelists, we integrate their research and expertise in a candid conversations among colleagues. If I could put it, it's going to be like a laid back fireside chat over coffee if we're meeting at the in the halls of the Hague and the International Criminal Court, or any of those conferences that we usually go to attend, just chat and chit chat about this concept. Then after everybody has spoken, building on each other's research and expertise, it will be opened up for a Q&A question from the audience. And for our audience looking at us, participating by way of YouTube, you have access to chat on YouTube, and your questions are going to be read to our distinguished panelists, and they will be able to shed more light on those questions. Also, importantly, this discussion, this Salon is being recorded, and the recording will be available on the International Summer School Salon page after the event is concluded today. So allow me now to introduce our distinguished panelists and speakers and guests for today. And I will start with Dr. Felix Ndahinda. My apologies about that. Dahinda is a consultant and an honorary associate professor at the University of Rwanda's College of Art and Social Sciences. And he was formerly an assistant professor at Tilburg Law School's International Victimology Institute, Tilburg, between 2009 and 2016. He also worked as an associate legal officer for the International Criminal Tribunal for Rwanda in Arusha, Tanzania. That was around 2009, and has been involved in various projects and consultancies. In terms of his academic interests, it covers areas around indigenous rights and issues, transitional justice, peace building, identity politics, and victimology. He has authored several publications covering these themes, including indigenousness in Africa, a contested legal framework for empowerment of marginalized community. It was published by Springer Asper Press in 2011. He has also authored the work on the Bemba Bayamulenge case before the ICC, from individual to collective criminal responsibility, that was published by the International Journal of Transitional Justice, and that was in 2013. And again, we have so many publications that is in the open record. If you can look at Google Scholar, you'll find all his publications there. Thank you, Dr. Dahinda, for joining us today. Also, we have Sarah Jane Collin, who is a cultural anthropologist with an interest in the social complexity of international governance structure and international lawmaking. Our research reflects a series of ethnographic engagement with the legal form as an increasingly international response to social harms, such as in the use of international criminal law to prosecute grave human rights violations, as well as in a next project, the legal framework governing refugee status and provision for asylum. Sarah Jane is an assistant professor of peace, justice, and human rights at Haverford College, United States. In terms of work experience, she worked previously at the TMC Assa Institute in The Hague. She also worked for the Coalition for the ICC, COAD, and Oxfam. She completed her graduate training at Princeton University, USA, and the School of Oriental and African Studies, SOAS UK. Also on the screen is Dr. Thies Bouquet, who is an historian of mass violence, transitional justice, and modern Africa. His research focuses on the causes, so I think I need to pronounce that well, causes and and the consequences of recent and remote historical injustice. Since 2011, he has been a member of the NIOD's Holocaust and Genocide Studies Core Team and the Transitional Justice Program. He's a visiting lecturer at the Graduate School of Humanities at the University of Amsterdam, where he co-directs the Holocaust and Genocide Studies Master's Program. Between 2007 and 2012, he worked as an international journalist, Radio Netherlands, Worldwide, International Justice Tribune, France 24, covering transitional justice, war crime trials, and African affairs. And between 2002 and 2007, he was a researcher at Amnesty International, the International Criminal Court, and the United Nations International Criminal Tribunal for Rwanda. And then between 2002 and 2021, he has observed over 150 war crimes and genocide trials at the international tribunals for the former Yugoslavia, Rwanda, Special Court for Sierra Leone, Cambodia, Lebanon, Kosovo, the ICC, and in Bosnia, Rwanda, and DR Congo. Welcome to this Salon, both Thies and Sarah Jane. Thank you for joining us today. And finally, we have another panelist who is running late, is a little behind schedule. When he comes on board and when he joins us, I will be more than happy to introduce him. And I did observe that I have not introduced myself. My name is Dr. Ayodele Akenroye. I'm a postdoctoral fellow at the Center for Criminology and Social Legal Studies at the University of Toronto. And also I'm an instructor in the International Criminal Law course, also at the University of Toronto at the Center for Sociology and Legal, Center for Criminology and Social Legal Study there. So that concludes the introduction so far. I will turn now to our guest, our distinguished guest and panelists. And I also want us to reflect again, drawing from the rich body of work that we have done over the years to try to answer this question that is very important. And how do you imagine it? And the question is going to be, who is a victim? And in your own experience, with your extensive experience in international law, how has that role changed over the course of the evolution of international law, whether you want to take it from the Nuremberg or before the Nuremberg or to the recent dispensation of victimhood around the ICC regime, which one? But the question is going to be, who is a victim? How do you define a victim? And how have you seen that role of a victim change over the years? Anyone can go. Okay, so anyone can approach that question and answer it, and they will take it forward.
All right. Let me probably start with some kind of very broad, maybe provocative kind of comments. Then probably others will pick up or trash whatever we have said then. I mean, I spent quite a number of years in an institute of victimology, which has been merged with other the departments. But I got quite a lot into the victim kind of talk, and especially I've worked with kind of distinguished colleagues who tried a little bit to, who wrote theses and many other aspects of research, looking at unpacking different aspects of victimhood. What is a victim? What is victimization? And what are the societal responses to victimization? One of the important things that maybe piece of work that I read early on in my journey, but also that I keep always referencing because it really was impactful for me, is an article by a colleague at the time, Jan van Dijk, a Dutch criminologist, who wrote a very provocative article entitled "Free the Victim." And the article basically looked at ways of unpacking the etymology, but also most importantly, the very historical meaning of the word victim in many Western languages that we speak today. Whether we talk about victims in English, the language we're using now, or in French, Dutch, German, and related Western languages, the idea of victims, according to Jan van Dijk, does send us back to a certain given specific concept about the origin of the word, but also most importantly, about the expectations from that etymology about how the victim looks like in society and what responses are you expected to have as members of a community vis-a-vis a person labeled as a victim. And what I found quite interesting in his article, of course, was that he traces the Judeo-Christian sources of the idea of victim. So victim sends back to the passion of Jesus Christ, this blameless, innocent person, God who was slain and so on. And I'm not a preacher here, so that's not my point here. But the article really, in these Western languages, sends back to that idea of suffering, someone who suffers, but also who is innocent and who is deserving, of course, of societal compassion or commiseration, if you will. So that's the first. And his article was quite imaginative because he was critical of this notion of victim, which basically boxes the victim into a given kind of space. And then also somewhat suggests or dictates societal kind of responses or considerations or even intuitions and reactions towards victimhood. And that impacts, of course, even how many societies still either respond to or treat victims of a given crime, and so on. So that was the first consideration, the very etymology in Western languages. And here I'm insisting on that because when you talk about victim, if you look at, on this platform, I know, and there are many of us who speak quite different languages than Western languages. So if you try to translate, it's always easy to make an intellectual journey and see whether the translation in other languages, or rather not the translation, the idea in the other languages translate the same idea of, passive, suffering, innocent individual who deserves the commiseration, but also, societal sympathies. Now, the etymology is important for me, of course, if we are then to talk about complexities of victimhood. So when someone is labeled as a victim, or how someone is labeled a victim rather, depends precisely on a given society, and how someone is accepted as a victim depends on a given society, and how then that society responds to the victim, whether it's an individual or even more complicated, a collective entity or collective body of people. That matters from one and changes or differs from one society to another. And I guess we'll unpack some of those as we go forward, of course, whether we then resume to international criminal justice processes, how those relate to domestic processes. And most of people here have maybe a legal connection. It matters as well, that etymology, but also how some aspect of victimhood could addressed or not. And finally, of course, probably there is a lot we can unpack about victimhood in the contemporary time. Many of us have been reading the current affairs, the news about Ukraine, refugees coming to Western Europe, how they are received vis-a-vis maybe people who are fleeing the different kind of atrocities, or people who are, coming to Europe from the Mediterranean. The differences between people, whether they can be labeled actually a victim or not, depending on who is speaking. Those are part of the questions of examining victimhood outside the narrower kind of frames of victims of crimes, that especially crimes of genocide, war crimes, and crimes against humanity. So broad concepts, hopefully we'll be narrowing on some of those. Those are the kind of few remarks I wanted to make. Back to you, moderator.
Thanks for that. Thanks for that insightful exposition on victim. From what I gathered from you, first of all, victim is a social category that people within that community put that label upon, and that is very interesting about that. But also, it's also a legal category that my get is drawing from the social category, depending on who is constructing making that linkages within the legal framework. Either way, but for now, it's a social category. Tease, Sarah, what do you think about that in moving forward that discussion around victimhood, who is a victim, before we get into the meat of the complexity that surrounds the word victims and how it's interpreted across different culture, different races, and different geographical locations?
I'm happy to jump into the conversation. Thank you, Felix, for those initial framing comments. I think really provocative and compelling, as you predicted. So thank you. As you were talking about the origin of the word victim and what that can sort of center for us, I began thinking about the origin of the word in Dutch, which is something I have not actually done so far in my work in international criminal justice. And it's interesting because the word in Dutch kind of raises this notion of sacrifice, of a sacrifice to a certain end. And so for me, that then raised these questions of utility and usefulness. And I think that's sort of where I would open with thinking a little bit about the position of victim within the discourse of international criminal justice. There's always been a gesturing to serving the needs of victims. There's always been a gesture, well, not always, it's a more recent development within the ICC, of course, but this sort of centering of this work being for victims. We can also see the kind of utility, the way in which the ICC proceedings need victims in thinking about evidence, of course, and where evidence comes from. But then again, there's an instrumentalization there of larger stories, right? Larger stories of victims being instrumentalized to really relate to a particular charge or relate to a particular crime, right? And so there's many ways in which the full stories of an individual victim can never be heard within a particular trial. So I think that that kind of instrumentalization following a particular logic of crime is sort of where my mind is going and thinking about the position of victims. And I think another comment I'd like to make, of course, is we've been talking a little bit about how this is a social category that is, of course, constructed. And I think that's where some of the difficulty comes in as well, is that the victim or the figure of the victim is always a compact figure, right? It's a compact made up of different accounts, made up of different stories, made up of slightly different experiences. And the effort to have a court then respond to the needs of that compact figure is, of course, inherently fraught and limited. And I think I'll stop there, and I'm sure we'll pick up on tangents.
Yep.
As we go forward.
Yeah. Exactly. Thanks for that, Sarah. Tees, any thoughts about defining victim? And there's something I want us to piggyback on again, is the evolution of victims across ages. And I did like what Felix said when he went to historical ancient Israel and Jewish conception of victim. But Tees, what do you think about a victim and the evolution of the role the victim has played in international law?
Thank you, first of all, for having me, and Felix and Sarah. I think you provided a really wonderful springboard for our conversations. And like you, Sarah, I was thinking about the Dutch word, and I really like how you sort of positioned and also explained to the audience, perhaps, how the Dutch word actually means sacrifice. And I think this really ties into what Felix also mentioned in terms of what the biblical stories teach us in our societies about victimhood. I also come at this subject a little bit as a stranger, which may sound odd. I study mass violence and genocide, but I've always looked only at the perpetrator side, because we try to understand why this type of violence happens. But obviously, also in your introduction, you said we also look at the consequences. And of course, the consequences are in law, not only for the perpetrators who would face punishment or whatever, but of course also for the victims. And I've always been struggling as a researcher to also deal with victims, because perhaps dealing with perpetrators is perhaps a little bit of a safe issue. It's not so much as a burden as well for a scholar. I teach Holocaust and genocide studies, and every year I see my students who read diaries or memoirs or books from victims. This makes them have a really hard year, right? So it's also a very complex issue just to deal with, and also to study. I also liked the way, and I think Sarah, you said it, how victims are sort of a utility, perhaps in the broader field of transitional justice. Of course, victims are a springboard for all these justice mechanisms and phenomena. But I think they're also sort of used in a narrative form, in a political form, but also in a form of branding. And I think this is also where a lot of international justice institutions perhaps derail what they actually are doing, right? So they send a message that they're going to do a lot of things for victims, while often actually not defining who victims are, or having in a court some representative who basically represents numbers. Sometimes in cases you have 2,000 victims who are nameless. So they also become somehow a footnote or an unidentified footnote in judicial proceedings. And perhaps they're much more used as well as a narrative tool in order to spark emotions, spark perhaps some legitimacy to what criminal justice does. And I'm perhaps not so much of a supporter or a fan of the role of victims in international criminal proceedings. Also, I come from a system where we also have civil proceedings, which I think is a much better venue for victims to, basically, they can do it after somebody is convicted, or they can pursue somebody, where they can have their grievances heard, where they can tell their stories. And especially in the Netherlands, we now have this universal jurisdiction phenomena, and you see much more that this is happening. And I think sort of it's a much nicer and better venue for them to at least get their story about. A last thing I want to say, and then we can jump to Alphonse, is this the concept of, is there a universal victim? I live actually quite close to a statue of Anne Frank. And I think everybody knows Anne Frank, a child who wrote a diary when she was hiding from her Nazi persecutors. But then is there one specific image of a perpetrator? And do we actually get to understand transculturally what a victim is in a very different situation, culturally, geographically, temporally as well? I find it very hard to find perhaps the ultimate victim. So in terms of conceptualization, it's as difficult as defining perpetrators. There's so many different individuals. And then if you look at ICC crimes, there can be basically 60 or 70 crimes you can be a victim of already, right? So you have already 70 categories, which you can sort of put people under, which also makes it very complex to think about. I think I'll leave it for that for the moment.
Thanks to this for those insightful comments and introductory comment. And now we are joined by Dr. Alfonso Mulefu, who is also one of our guest distinguished panelists for today's Salon. In terms of bio, is a senior lecturer at the School of Law, an acting principal of the College of Art and Social Sciences at the University of Rwanda. He previously worked with the International Criminal Tribunal for Rwanda, the International Criminal Court, and the Gacaca Court. He holds a PhD in law from Tilburg University, the Netherlands. His specialization is in international criminal law, international criminal investigations, transitional justice, law of war, human rights law, public security, and rule of law. He has published on those subjects with his latest book being the institutional independence of the International Criminal Court between a rock and a hard place. And that publication that book was published in 2019. Welcome, Dr. Mulefu, to this, Dr. Alfonso, I think, to this discussion. We would like your insights on who is a victim, the topic we are currently discussing or having a conversation around, and who is a victim and has that role of a victim evolved over the years. We've heard about the epistemology of that word, from Dutch origin, from Israeli Jewish origin, and from different conception and the complexity that started that I engage with that. But for now, let's just sit back and reflect and drawing from the rich body of work we've done over the years. Who's a victim? How do you define a victim? How do you see a victim within the framework of international law or outside of even international law? How do you see the conception of a victim? Dr. Mulefu, please.
Thank you very much, and I'm really sorry for joining late. So probably I risk repeating what others have already said, but to avoid too much of repetition, let me go with the technically applied legal definition of a victim as someone who has suffered harm, directly or indirectly, and that harm can be suffered individually or collectively. So having said that, and with all the respect to those that are involved in activities related to speaking for or on behalf of victims, I've come to a conclusion that actually knowing the needs of victims is something that is really difficult to be able to touch on. And the question I have always, that has always been difficult for me is whether we should see victims in their totality as a collective or as specific individuals. And whether you take them as collective or specific individuals, it means something different in the kind of responses that you give. But also, how do we place the society in which they belong? And you will realize that most of these crimes where international criminal law is applicable are crimes that are dealt with when they have reached a highest magnitude, what you can say like the climax. But you will find that the victims have suffered other sequence kinds of victimization, or let's say marginalization, that when you reach to the level of saying, where do we start to provide justice? Again, we will come back to the definition of justice. What do we understand as justice? Because it might not mean the same thing to all victims. And even if victims might have suffered the same crime, they might still need the same different ways of responding to the harm they suffered. Yes, we can take it as an open statement that victims need justice. Then we need to define what is justice. We have what is already provided for in the UN general principles for the victims of crime and abuse of power, and what is provided for in these other international instruments. But whether it is the compensation, whether it is the restitution, whether it is guarantees for non-repetition, whether it is providing prosecution, all those kinds of categorizations that make up the victims are also aspects that need their tailored responses to each particular situation. So to not make a wrong submission, my view is that victims will need different things, but since as a society, also a society would need to move forward. I give a practical example. After the 1994 genocide against the Tutsi in Rwanda, we had over 1 million people killed. We had their properties destroyed. We had a society that had also been destroyed, not only the victims, but also the society. The state infrastructure was non-existent. You have to respond to the needs of victims, but you have also to respond to the needs of other members of the society. Because destruction also concerned the entire society. So how do you balance compensation, for example, for an individual who has suffered a particular crime with an individual who currently needs health care, who currently needs to be uplifted from the poverty situation he or she is in? How do you provide the roads? How do you provide these basic needs that make a government function as a government or a state functioning as a state? So victimhood needs to be understood from a rigoristic point of view. As I said, you have suffered harm directly or indirectly, collectively or individually, and you deserve to be repaired for the harm that has been suffered. To what extent and how that translates into real justice is something that I think we will quite have a lot of discussion to agree on. So I submit from there.
Thanks so much for your contribution, and it's very insightful. The categorization of victim is very complex and problematic, and that's what you said. Do we talk about the victims from a direct, direct victim, indirect victim, and when we're talking about reparation, do we talk about it from a collective aspect or from a individual aspect? And these are some of the issues that the International Criminal Court has been struggling and dealing with for the last few years on how to award reparation to people in different conflict zones, maybe in Uganda or in DRC. And also the issue is going to be what they really mean. What do they really want in terms of reparation? What's the capacity of the institutional legal framework able to provide, and how does that translate into the materiality need of those people on ground? And again, this is also what you just summarized, and is very important, is the fact that societies such as Rwanda, such as Uganda, or any other country, even in Syria, that are trying to come out of conflict, or like the Rwanda genocide that you talked about, face a lot of problems. And again, one of the issues is that aspect of a victim, who is a victim and who is a perpetrator, particularly when both of them are intertwined. There's some, in terms of Rwanda, there's some victims that actually committed crimes, and there's some perpetrators that actually did some good. So how do we categorize them? How do we bring them, reconcile those extreme polarity? And those are some of the complexity that we are exploring here. And a question I would just want to ask, drawing on everyone's opinion, is and I think Afonso was talking about in a way, is there going to be can there be a relationship between victims and also the perpetrators of those crimes? We can put in victimology talk. Is there a relationship between victims and the crime? Is there a way we can unbox this aspect of that the victims and perpetrators are extreme polars that they don't meet? The question is going to be, can they meet? Do they meet? Would they ever be able to meet? Or can we reconcile them in such a way that we can take a nuanced look and say, yes, these two concepts do meet? Victims could be perpetrators could be victims. However, I want us to forget about the dogma around this literature, around the issue of victims and complexity around it, and ask ourselves a critical question. In my years of experience, is it possible that someone can be a perpetrator and also be a victim at the same time, or it's not possible? And let's just end that discussion. So I wouldn't mind if you take an opposing view, depending on what you feel. Tees, Sarah, Felix, Afonso, you can take a opposing view on that, and we try to reconcile it and break down the concepts that are loaded in this complexity. Anyone can go. Anyone that wants to build the cart, let's go.
Let me come first, and then I try to be provocative.
Please feel free.
Yes, so you
I think we're having some internet lag from Afonso.
Alfonso, I don't know whether you can hear us, but we can't hear you.
Yes, but the question, I can hear you. Probably my internet is breaking.
Yes, can you repeat yourself? We can hear you very well now. Can you repeat yourself again? Yes.
Yeah, I was saying yes, it is very possible. But and this is something that I always struggled to explain when I was working in the Gacaca courts. For example, when the genocide against the Tutsi was happening, it doesn't mean that thieves were not stealing. It doesn't mean that murders were committing those crimes. It doesn't mean that ordinary crimes, because our societies commit crimes. That's why we have law enforcing agencies. So it is not that when these massive violations of human rights or these serious international crimes, when they occur, that they make those individuals, those criminal individuals, stop their criminal conduct. Still, crimes are going to be committed alongside these other international crimes. So it is possible that you could be a victim of a certain crime of an international nature, but still be someone who would, in ordinary circumstances, would have committed even an ordinary crime. So in a situation of these massive violations of human rights, there are different categories of criminal conducts that happen. So the challenge comes that the definition, this is where the definition becomes very important to lawyers, but not so important to ordinary victims. It is important that I understand that when I'm with someone who suffered the crime of murder in its ordinary sense, because it is possible that the crime of murder would occur. We can go and give examples, but I think it is common sense that when these international crimes are occurring, it doesn't mean that ordinary crimes do not occur. So the challenge is, how do you separate the two so that you don't wrap up everything together? I submit.
Okay. Thanks so much, Amfoso, for that. Sarah, T, Felix, what are your thoughts? And we do have one question we're going to discuss with soon, but Taze, I see your hands up. Yes, please.
Yes, I can go. Thank you, Alphonse, for your insights, also from the Cachachas. And of course, that was such a complex justice endeavor with so many people involved, with so many interests, and so many categories of perpetration as well. And I think you really dive into the complexities of what victimhood is and who is a victim and of what. And you also just raised a thought with me, is who is the ultimate victim? And you talked about murder. But if you are a victim of murder, what can you do? Can you achieve some kind of justice? No, I think all avenues are closed. So I think there's a very specific category of crime of which you can be a victim, of which there is no revenue for you to go anymore because you don't exist any longer. So who then becomes the victim afterwards? Is it family members, or is it the generation that comes afterwards? And here we connect perhaps past and present. And I think questions and research on transgenerational issues of victimhood, of course, are also very, very important and very relevant in a lot of societies and in a lot of situations. So that I think is a very interesting question. Can perpetrators have been victims? Yes, of course. Just look at the case of Dominic Ongwen at the ICC. I think that's a textbook case of where you have a child who was abducted when he was 9 or 10, was forced to do a lot of awful things. And when he turns 18, by law, he becomes the perpetrator. I think this is a very complex case and we can criticize it a lot. So I've done so in certain writings. But of course, you can also be a victim of a system or of massive crimes, of atrocities, and pick up arms and start to commit atrocities as well. And I think we've seen this in Cambodia, for example, where a lot of villages were bombed for 5 years by the United States of America. And a lot of these people who were bombed, farmers, joined the Khmer Rouge and of course became perpetrators afterwards. Many of them were very young people. Their parents were killed and they started to join a system or were forced to join a system. So I think that's another complexity. Also, I see in the chat that we also just only think about victims as humans. It's a very anthropocentric view on the world. And of course, that's what law does. We just care about ourselves, but we don't care about the 10,000 other species that live among us or the environment. So I think that's also a very critical and interesting question that is slightly under-addressed in international law, except for the case for Mali, of course, at the ICC, where the victims basically were 10 buildings and a door of a mosque. Right, very material victim. Yeah. So I think that's I think another avenue to think about and perhaps also to consider, also to decentralize ourselves as human beings, opposed to all the other species that we are living together with. So I'll leave it there. Perhaps I tried to pick up on Alphonse's promise to be a little bit provocative.
Thanks, Lisa, for that. And again, you mentioned the issue of Mali, and that's also one of the areas I wanted us to take the discussion to. And again, drawing from some of the questions in the chat room, is there any way we can think of victimhood outside of this individual victim? Myself, I was hurt, I was from a non-human place, which is talk about the Timbuktu or the Mali culture, the social cultural property. Well, beyond that, are there other ways that we can think of victimhood beyond those categories and open up? And this is going to be a reflection for Felix and for Sarah that's not yet spoken about that. Is it possible for you to look beyond it in terms of community victims, which Alfonso did talk about when he talks about indirect victims? And there's a lot of legal scholarship that talks around it, that victims cannot be individual in terms of direct, which we are used to, or it's easy for us to navigate in the legal framework, but it can be expanded. So the issue now is going to be, how do you conceptualize that? How do you think that? How do you imagine that if you have to expand it across board beyond just this individuality that is involved in it? Felix and Sarah, any thoughts on that?
So much to pick up on here. Is that okay if I go ahead, Felix?
Ladies first, they say.
Thank you. Certainly, I think the Ongwen case, of course, is one where this is going back to an earlier theme that we were touching upon, right? Can we think a little bit about how these categories meet? And I think the Ongwen case, as you were saying, Thais, is certainly a textbook case. What's also interesting, I think, if we move forward, actually, no, let me say with the Ongwen case. So what I think is interesting about that shift from child to being an 18 and the age of majority is, again, this teaches us something about the understanding of the victim, or the understanding of an ideal victim, right? So there's an idea of innocence, there's an idea of passivity, and then once you reach the age of majority, once your mind has matured, although I suppose neuroscientists would argue that that is not at 18, that is later, but then you have a free will, and then under our logics of law, you become accountable for the actions that you took when you were an adult. So I think the Ongwen case is particularly illustrative to get us thinking a little bit about the position here of victimhood and perpetration, and how those positions might shift. I'm also really interested in the Almaty case and this thinking about loss beyond the individual, right? Thinking about loss as what it might represent for a community. But what then is striking is what law, the logic of criminal law that we see before the criminal court, the International Criminal Court, what that does with that story. And I understand, I believe that the Almaty case is one of the few cases where there are actually individual reparations being granted to victims, right? So we've just established that there is an understanding of collective harm there. Yet after the conviction, we're seeing individual awards of reparations being made to family members who can actually attest that they have a form of lineage or a form of relationality to the figures that were represented in these buildings. So I think that is an interesting paradox there, right? Where we have a collective understanding of harm and suffering, and then a kind of one of the very few efforts, I think, to look at individual reparations, whereas many of the other cases, and there's actually not that many that are at the reparation stage, but to the extent that we can see, the reparations are collective by and large, and even symbolic, right? So I think that's an interesting paradox there.
Right. Fascinating. Thanks very much, Sarah, for that. Maybe in picking on what was raised, let me take a step back again from the concept again. I mean, I started with a framing question, and I guess quickly already the discussion shifted into the legalistic kind of takes on victimhood and justice. Rightly so, we are a panel basically mainly in the international criminal justice kind of series. That being said, I guess it helps also when we look at it, the ideas beyond the narrow lenses of law, if you will, and especially the necessity of looking at social constructions of victimhood, and hence the idea of also how different societies frame victimhood and so on, and justice for that matter. And for me then, if you look at contemporary debates around issues, for example, of historical reparations, I mean, I live in the Netherlands, Belgium, just recently instituted a colonial commission to look into Belgian past in Congo, Rwanda, and Burundi. We are talking about issues here of wrong, harm, and some form of justice that we still have to be framed and so on. If you look at, I mean, just recently, I understand there was some royals from the UK who was in the Caribbean, and issues of the past and the need for teaching the monarchy or not. That was the debate which was in the news. And that has also to do with a certain given specific form of past wrongs and some idea of justice. So when looking at both victimhood, I'm looking also at all of those kind of issues of historical justice, social justice, distributive justice, and the complexities that are attached to the framing of victimhood in that kind of type of narrative as well, or that kind of frame. So as much as we concentrate on legalistic definitions of with the Victims Declaration of the UN of 85, the Bassioni principles of victim for serious crimes and so on, or the ICC law, if you will, let's keep in mind also these many other different debates that make a little bit the discussion of victimhood today interesting. And that's very important to me because the historical part is very important when looking at some of the contemporary debates. So the historical injustice, for example, is something that, at least in many of the African contexts today, several dynamics that take place, including the many crimes that are client to the ICC, do happen because of some given colonial legacies, if you will. And for that, both the historical aspect of justice matters, including also victimhood, within the complexities of framing who is victim now across generations, if you will. So that's one. So the past does affect the present, if you will. But also very importantly, since that past does frame the present, the collective does bear quite a lot of weight in this kind of spaces, if you will. If you look at the dynamics of conflicts, the way they have occurred, whether it's in Rwanda and the genocide against the Tutsi, whether it's in Burundi and with the different episodes of killings already from the 60s, whether it's in Congo today, ongoing crimes in the Kivus, in Ituris, in the whole plateau of South Kivu, many of the mobilized narratives or reasons for killing, for example, have to do with some legacy, historical legacy, whether colonial administration's framing of identities and belonging and so on. And then the crimes are committed pretty much with a collective component in them. So the very essence of many crimes, ICC crimes, for example, has the very collective aspect to it. So two of my writings really focus on that. The Bemba Banyamulenge case focuses on that, but also very importantly, the one I wrote on subjectification of victimhood, whereby when you deliver justice in such kind of context, it's very difficult and probably a utopian idea of rendering justice to individuals when the framing of the conflicts, but also the very essence of the dynamics of conflicts are collective in nature. and because of a certain given, of course, historical legacy. So that being said, yes, we can talk about victimhood collectively, and I think I have quite elaborated on that, among many others. Of course, there is an emerging body of literature on that. But I guess the shortcomings of even focusing on the kind of ICC law is precisely that it does very badly fit with that kind of type of justice, because even when they try to do collective reparations or collective anything, it's skewed in a way because the international justice processes are very terrible at doing history, at doing sociology. They have this very kind of narrow lenses in which they deal with both space and time. And in that sense, whatever responses that come about tend to be quite very much artificial in nature. So the point here being, yeah, as much as we talk about victimhood as a very complex phenomenon within specific kind of narrow spaces and lenses of a certain given conflict, the important also to take into account space and time in looking at the different layers or spheres of justice and victimhood is very important, and linking different kind of aspect of victimhood and stepping outside the narrow, sometimes very artificial kind of spaces, boxed spaces of law, sometimes may be salutary in looking at and responding to certain given aspect of victimhood. So remaining vague actually here and broad in order to be a little bit more narrow as I go. Back to you, moderator.
Thanks, Felix, for that rich elucidation, if I could put it on the rich insight into that aspect of between the individual and collective nature of victimhood, and also the historical aspect of it, that also the struggle of International Criminal Tribunal to extrapolate himself from the strict legal bans and incorporate other forms of meanings to that conception of victimhood. And that brings me to something, and it's going to be a question I will ask us to reflect on, and it also brings me to this conception where we talk about international law or international criminal court being there for all the victims across all different geographies, whether it be for Syria or Uganda or in Ukraine or across board, whether they've ratified the Rome Statute or whether the UN Security Council is going to make that referral or whatever. So we assume that international criminal justice is meant for everyone in terms of victims across board. But the reality is that is not correct. That is actually the opposite. I now find this a temporality argument whereby victims that were victims of crime before 2002 are not covered by the present international criminal law regime, or victims of even in a country like Uganda, victims of this particular region are not covered because the prosecutor is not looking at that side, is looking at this side. And therefore that means there's going to be loss of recognition for some people, for some victims that in the streets, even in the street legal category, might be victims, but they are not, the prosecutor is not looking at them or feels that it can win a case there or whatever. Or even if they are not within the street legal category, in the social construct across in those communities, they are victims, but the International Criminal Court or International Criminal Regime is not looking at them. So they are all recognized. And there's something that I also have to do with, and I also want to, I'm just trying to ask this question, is that in that situation where victims are excluded from the main dominant international criminal law justice project or excluded from trial, are there ways by which the harm can be recognized? What recourses do they have to have the harm, to have loss of life, loss of property, loss of identity recognized within the ICL framework? And then the other one I want us to think about is the aspect of, is there an injustice where some victims are not being had and some are being had, or some victims are excluded? So it's a twin question I'm asking. One is, what are the recourses for them? if you are not recognized by the ICL regime. And two, I want you to think provocatively around the concept of the injustice of not being heard, despite the fact that you're a victim. And this we can bring it close home. When we look at Syria, for the last 10 years or 15 years, or 10 years or thereabout, they have not been heard. There's an injustice ongoing there where victims are crying out, I need to be heard, but they are not heard. So how do you bridge those gaps? Anyone again can go for in explaining and sharing your thoughts around this concept.
Now, if I would come first, for me, I think we expect from international criminal justice what international criminal justice cannot deliver, and that it was not made to deliver. We have examples of recent international criminal tribunals and the courts that have existed. When you look at the ICTR, ICTY, go into its record in terms of providing justice that is directly impacting victims, other than the punitive part of it. Go to the Special Criminal Tribunal for Sierra Leone. Go to the current ICC. The funding of the court excluded the mandate to the funding of the trust fund for victims. And the trust fund for victims that is providing the symbolic type of reparation that you can think of cannot provide beyond indeed the symbolic form of reparation. So you want to tell me that by taking out, without undermining the conduct of taking out to the militia leader, but you wanted to tell me that taking out one militia leader in a community that has suffered serious crimes is going to provide justice to the victim whose neighbor that participated in the killings or the destruction of that victim's livelihood is still there. And you have not provided anything in place to address the situation. Whether you're talking of the conditions that contributed to the commission of the crime or to the consequences that came out of the crime. And here, I think you have to come back to who is responsible for providing justice to the victims. And even for those who support the work of international criminal justice will tell you that the primary responsibility is on state. And again, when we talk about the responsibility of states, we talk about the responsibility of states in the totality of what states have to provide, not only to the victims, but also to the bystanders, but also to the general population. So then it comes in the issue of resources. And the reason I want us to really focus on these issues is that we want to be pragmatic and see what is possible. And I remember coming to the University of Amsterdam one time. There was a seminar that was talking about compensation to the victims, and the title of the report was "How much is the human life?" So how do you quantify the justice that you provide? So the aspect of satisfaction and the categorization that we make when we are trying to provide justice, because you will find that we will put crimes in different categories. We will say those who committed, for example, rape will be given a much higher sentence than the one who committed murder. But does that mean a lot to these individuals who have suffered these crimes? The elite have decided to make, and we make them on behalf of the victims, and in most cases without consulting them. So how do we make sure that the victims of a particular situation that we are talking about are indeed involved in the things that we claim are made on their behalf? I stop there for the moment.
Thanks so much, Afonso. Sarah, any thoughts? Please let's hear.
Yeah, thanks for those really provocative prompts, Alphonse. I'm not sure that I'll speak to them directly, but I do think they'll come up in the conversation. I think to that original question of how can international criminal law accommodate victims who are not necessarily victims directly of the case or of the charges that are being brought. I think that's a very interesting one. We've seen in ICC discourse, at least, right, the discourse coming out of the prosecutor's office, but also the discourse coming out of the various units that support victims. We've seen this logic coming out of saying you can be a victim of a case, but you can also be a victim of a situation, right? So you can be a victim of a case, and where particular charges are being brought, to be registered as a victim of a case, you have to fill in this form that really demonstrates that you can establish harm related to the particular charges in the case. And that can become quite fraught because we have seen prosecutors withdraw charges. We have seen them change charges during trial. And that then means that particular categories of victims then are considered otherwise. So you can become a victim of a situation, say the overarching situation in Uganda, but not necessarily be recognized as a victim in a particular case. And so we have that logic at the ICC. I also think it's important to remember Thijs's comment that there are other avenues of law that victims can use, right? So the avenue of civil law, we have seen do interesting things in this realm. And I think that the civil law really helps us think a little bit about remedy and value and how do you calculate, right? We've seen very interesting formulaic calculations of measures of accountability and then measures of what that remedy will look like. A final comment that I wanted to make here, and I'm thinking about this because I was thinking about that comment that came up in the chat, I believe, on a victimless crime or how do we really position victims. And two cases that I've been working on recently relate to Liberian American citizens. So I'm currently in Philadelphia, and we've seen in recent years prosecutors in Philadelphia bringing charges against Liberian American men in these cases who have been in the United States for decades and are now being held accountable for their involvement in criminal conduct during the first civil war in Liberia. However, the techniques that they're using for that are not actually techniques of international criminal law or charges of international criminal law. They've been using immigration law to say, in the act of immigrating to the United States, you actually lied about your affiliation, and therefore you are on trial for perjury, you are on trial for giving falsified statements, you are on trial for any false statements that you made during the course of applying for citizenship. When these convictions were achieved, the prosecutor came outside and said, this is justice for victims. Right? And I think that's a really interesting move there to say we're using immigration law. The remedy here is perhaps carceral punishment, perhaps deportation, most likely deportation. However, all of this is for victims in Liberia. And we see large involvement of NGOs from Liberia. We also see a Liberian diaspora saying, this was not the criminal that I wanted to see prosecuted, right? Our situation is much more complicated than American juries can actually represent. But I think that notion of how do we use crime and how do we use the logics of charges that are available to us and how does that then translate to approximating justice for victims, I think is an interesting question.
Thanks, Sarah. Felix, I see your hand up. Yes. You're on mute. We can hear you. You're on mute.
Of course.
Yes.
Sorry, I don't speak mute. So, so your question was provocative around like the justice of not being heard, and in this case, you talked about other situations. Let me start by even unpacking a little bit that being heard aspect of itself, and I think Thijs and probably Sarah also at the beginning did touch on that. There's this premise in international criminal processes that, I mean, when victims are participating, I mean, we are doing justice to victims, and whether individual and collective, and the colleagues already talked to the technicalities of it, victim of situation, victim of certain given specific case in ICC law. We have followed narratives and discourses a lot on that. But a little bit entering into the sociology of that always matters as well. I mean, when ICC statute was adopted and then the court started functioning, and then the first case came, I remember reading the reports here in the Netherlands about the conclusion of the Lubanga case, that all of those human rights organizations, it was, today the victims have won. This is a day of justice for victims. And believe me, I was, and as I am still puzzled by those kind of statements, even then, it's not like in hindsight, because I understood more closely the situation. Lubanga was being tried for circumscription of child soldiers from his community in an inter-ethnic conflict, or at least if we frame that, that's a narrow, of course, characterization, but at least with the main most serious crimes being committed between Lendu, his community, between his Hema community against the Lendu and vice versa. But the victims of Lubanga were Hema, because those were children from the Hema community who were enrolled in his party. Now, talking to a lot of people from Ituri, especially from the Hema community, that didn't make any sense, that those children were victims. They were saviors of his community. But still in The Hague, people were dancing and celebrating about the day, the great day for justice for victims. While at a given time, at the same time, the Hema community was very much divided around those concepts of whether actually that was a day of justice, whether these were victims, or rather people had been, and I saw a comment there, instrumentalized by an international justice process. Now, when we're talking about then, therefore, victims being heard, even those participating in these processes is something that we need to unpack. A second example, I mean, my 2013 article was on Bemba. And at the time, the process was in motion. He was being tried in The Hague for crimes committed not in his native DRC, which is a different story because more crimes had been committed there, but in the Central African Republic. So he's still being on trial. At the time, I think it was a record, there were 5,000 participating victims, 5,000 plus participating victims from Central African Republic. Now, we know what happened in the end. The case was unsuccessful. Bemba was released. He's now in competitive politics in the DRC today, back in the game. But most importantly, what happened to those 5,000 victims? I mean, small actions here and there from the court and so on. But those were people who are being promised justice and have never seen any, because there is no successful case yet, really, of the same magnitude before the court in the Central African Republic, despite now the proceedings with the new court in the country. But even with the dynamic of participation itself, and here again, now I'm unpacking the word being heard. I mean, I've been in many Hague conferences and talked to all of those guys who are part of the participation process. You have a number of Western guys based in The Hague who make touristy kind of visits to the terrains and deal with, sometimes you have two attorneys dealing with those 5 or 2 teams dealing with those 5,000 people. So actually, the majority of those people will never have seen actually the main attorney dealing with the case. So can we genuinely talk about those individuals as participating and being genuinely heard when their voice is buried within just 5,000 other voices within a justice process? Can we really genuinely talk about this, the persons having been heard? I have been always very critical of that kind of dynamic. So much of the promise about promise about justice for victims, especially the collective dimension of mass crimes, I think has been just that, more of a promise than something that can ever be delivered. And probably part of the problem was the ambition and the promise that was not to be made, because in practical terms, it's just a kind of an impossible promise. Okay. Finally,
go on.
Sorry.
No, go on. Sorry, go on. Go on.
Yeah. Finally, then talking about the other, not even with outside the bounds of being heard or not, that's where I was going a little bit with unpacking and problematizing victimhood, and going back to Jan van Dijk's paper about the idea of victim. Who is the real victim? This slachtoffer in the Netherlands. The suffering, sacrificed innocent person. I guess the discussion has already unpacked about the idea that within many conflicts, the binary is not always something that you can keep. Conflicts are dirty, they are complex, and someone can be a victim and perpetrator, and so on. That doesn't necessarily diminish the victimhood, and so on. But at the same time, very importantly, then what societies accept as victim, whether they are local societies or global societies, now international criminal justice processes, is very problematic, of course. And I mean, we know nowadays that if you look at narratives about different conflicts, we have hundreds of conflicts today in different parts of the world. So consider just two things. You talked about Syria, but consider the attention that you have on Ukraine today in global media, with nearly every single kind of big news kind of outlet being present there, versus what you have for many years in Yemen, probably the same actors present in that terrain, versus what we have in the Congo again that I mentioned earlier, and many other African contexts, if you will, versus what you have, of course, in Myanmar, which has relatively gained more attention than the average, and so on. So politics always come into play in terms of deciding, and I guess that has been analyzed in many existing literature, but in deciding what victims are considered real victims in both domestic, but also increasingly in international criminal justice processes, or in international politics generally, because sometimes, of course, we need again to step outside of this justice processing motion and go back to the politics that inform certain given decisions that are taken in regarding certain given category of individuals or collectives as victims or not. Back to you.
Shall I pick up on some of the many things that have been said just in the past few minutes? First of all, Sarah, I think you really pointed at an important issue, talking about Mali and the symbolism of justice. And I remember very well as well that the ICC also granted or gave a reparation of €1 to the international community. And I also found that interesting that also in international community, I don't believe that exists, of course, in the first place, because it's too complicated. Gets €1 because there's an idea that perhaps the ICC believes that we all share, which is perhaps a common narrative about cultural heritage. So perhaps we can also frame it as a crime against history, right? So it's also narratives being destroyed. Just think about Lemkin's earlier ideas about cultural genocide. And of course, the Mali case was very much framed in that language, in that discourse. And I'm not sure whether a lot of people actually picked that up. But I think it's an interesting venue to also look at. And then Felix, I think you also implicitly actually brought up a new type of victim, and that's the victim of international justice. Now you were talking about Bemba, and this is just a side comment I was going to make, but these people are acquitted because the ICC is very, very bad in doing its job. I mean, it comes up with not very good case scenarios. The evidence usually is not very good. And then they have to acquit people, and those people are going back to court asking for reparations, right? So have they been a victim as well of wrongful prosecution, of detention in Scheveningen or The Hague? Think about Jablé Coudet, who's still in The Hague, right? And he's still claiming reparations from the ICC because he's fully acquitted, but he doesn't have a passport. So I think this also creates perhaps a question on the legacy of what international justice actually does. And that also brings us, of course, to what Malefu also brought up, is the expectations raised by international justice, or this so-called international community. And when I always think about the ICC, you have to think about it historically, because it was created in the 1990s. Everybody was living in this positivism of human rights era starting. And I think they made a huge mistake of creating an ICC by thinking that they were creating a human rights court. But it's not. It's a criminal court, right? And criminal courts deal with perpetrators, and the sole purpose is to either find them guilty or acquit them and then punish them or not. But now you have this complex new category involved in criminal proceedings, which are the victims, which are represented by lawyers. But basically what they do is represents some phantom or a fantasy. And I think this is perhaps this ideal victim, which of course doesn't exist. But then when you think about it, they can basically just join the prosecution. So actually you have an extra table there, but usually they provide the same narrative. Recently, of course, you had also one of the leads representatives of the victims applying for the job of prosecutor. Right, so you can already see that they basically have the same objective. Perhaps it's a little bit moot, and I always see when I look at the ICC that victims are a little bit of a token of international justice, and what that justice then actually means. I think that's very complicated. Another issue, Felix, and I found you really hit the mark, is that the ICC doesn't try to understand conflict. It cannot.
I think we lost Ty. I think we lost him. Interesting. While we're waiting for him to, can everyone hear me? Felix, can you hear me?
Okay. I can hear you very well.
Okay, so I think we lost Ty. We can see his face, but he's frozen. And well, while he's coming back, again, I hear the rich discussions, Afonso, Felix, Sarah, regarding these. One question I want to push back and I also want us to think about is those left on the margin. How can we bring them back and give them justice? How can their harm be recognized and repaired? And again, the next question when Ty comes back is going to be on the issue around the contestation around reparation. Well, here's a question I'm trying to push further and ask if you can dig into it. If you don't have the answer, that's fine, but if you can dig into it. For those that are left on the margin, those that are not hard, what recourse can they go to? And as an example, quick example is going to be national prosecution. They can use domestic criminal law framework to try to do maybe seek the fair act for common laws system to see get the fair act of the Attorney General. Ty, I will see about 1 second to get the consent of the Attorney General to initiate private prosecution. That's an aspect that we can use to get them to, or maybe a coalition of NGOs, international NGOs that can start holding those government accountable. I said, even though the international criminal law regime says, well, we are not looking at those, we are staying, we are withdrawing charges, we are not proceeding, we don't have enough, the reasonable prospect of conviction is very low, but you can still provide some form of reparation to them. So I'm just thinking, what are your thoughts around that recourse? What can we give to them? Those have been left out of the discussion. Maybe they were not integrated into the current international criminal trials going in different tribunals.
I mean, I wish I would have been interested in hearing more about what I have to say. Probably we come back to that argument. I mean, I guess here you're talking about victims from situations that are already being processed before the International Criminal Court or courts, for instance. Is that the case?
All of them, whether being processed, whether not being processed, where take for instance, in any country, the prosecutor is looking at one particular site and ignoring other sites. How can we get them to be recognized, those that are not being processed, and see how what kind of justice can be delivered to them?
I see. I mean, that's a very complex question, of course, if you have to imagine the different kind of scenarios and different kind of processes, the different kind of landscapes and justice systems. And I guess the answer already starts from there. The easy part is probably to start looking at already what is quite richly explored in the literature about those victims left out of, let's say, kind of cases that, or situations that are before the international tribunals like the ICC. Or let's take to the ICC. Even in kind of the Bemba case that I invoked, or the Congo case where you had quite a few individuals tried and convicted, or the Mali and so forth, you have still the larger majority of individuals who are victims in the same situations who are not participating. Of course, it's easier to say they should go to national courts. But keep in mind, again, the complexity of the reality. The whole idea of ICC exercising jurisdiction is this idea that local authorities, local judicial authorities are either unable or unwilling to prosecute or adjudicate the cases. Now, I increasingly hear and read in literature these ideas about, what is it again? Positive complementarity or reparative complementarity and so on. And the idea that all of a sudden, even if things have been tried by the ICC, somehow national courts should be able to address some of the reparations issues. And to me, it defeats a little bit even the very essence of ICC's intervention in the first place, unless you are talking about some ICC having some kind of pedagogical, let's say, function here. We are teaching the locals how to do it, and then they will step up. But beyond that, it's an impossible question, if you will. The argument is, though, always, even the first type of answer we gave was that even those participating in international processes might get something, but whether we call that really the justice that they wanted, participation, being heard, to me, always being heard implies this idea that the victim who is being represented in those processes has a direct line, more or less, with the person doing the representing. And I guess we have a large body of literature that has explored how that is not necessarily the case even in international processes. Now, that already, the participation itself, the justice that is rendered there already is problematic. Now, going then to even those who are not part of that limited form of justice that they get is, of course, problematic in itself. Of course, some of those contexts do evolve, and victims eventually get space and occasions to deal with. To ask for justice. Rwanda is a good example, for example, where when the ICTR was created, the idea was that you needed that tribunal in order to deal with what had just happened. But eventually, with the governance going on, whatever criticism we may end up having with Gacaca and so on, Gacaca did exist. They tried even more people, they processed cases, and then the society tried to start moving on. And in a number of other contexts as well, justice may always, there's this idea that these are prescriptive crimes, so justice can always intervene there. But I guess the politics always will remain, and that will, since your question was broader, that, what about the victims of Syria and Myanmar and so on? The question remains. I guess the simple answer would be, we would hope for a fairer international system where all crimes are considered equally. But then the remaining politics, I guess there are always, and there will always be, victims who will fall out of the cracks and not be heard, not even be considered as deserving of certain given kind of consideration, whether before national courts or before international processes.
Thank you. Kai, please, we happy to have you back. We lost you in the middle of your thoughts. due to internet connection. So again, please complete your thought, and if you have more thoughts around this issue of what are the recourse for them, tangible recourse of victims that have not been recognized, please be more than welcome. You are more than welcome to share these ideas.
Sorry, first of all, for falling off the internet. I don't know what happens, and I lost my train of thought, but I'm going to try to pick it up. And I think the question is also whether international justice can actually understand the concept of victim itself. I mean, there was the first question of our Salon, of course, but I'm also quite unsure whether justice practitioners understand really who is the victim in each specific context or situation as well. And I think this is a point that Felix also made, is that law, of course, is believed that it can solve a lot of world problems, but of course it cannot. It's not a healer of all nations, and we should not believe that it is. But I think one of the biggest problems, of course, is its mandate, but also its incapacity to understand history and sociology and perhaps anthropology, is to understand deeply what has caused mass violence in a specific situation. And of course, you've referred to Belgium and Rwanda and Burundi and Congo, but there the crime, of course, started in 1884, 1885 in Berlin, during the conference that partitioned Africa and everything that came afterwards. And of course, the ICC is in no way capable to look at that or to consider that even. I don't think even the ICTR did so in its 20 years of existence, actually looking at the root causes of what happened, and also address the much layered complexities of victimhoods, which is much more historically informed and perhaps also created. I mean, it's also a crime of colonialism, including by the United Nations and the League of Nations, which basically ran those places through a system of protectorates and mandates, right? I mean, it's much more complex. So the international community actually is also a perpetrator itself in those cases. What are then the recourses? Felix, you just mentioned, or I heard the word complementarity. And of course, Sarah, you also talked about the cases of the Liberians in the United States. In the Netherlands, we have this International War Crimes Chamber, which hits 15-minute cycle from the ICC and does much more cases and situations than the ICC. But also it's a very intimate space. A couple of years ago, I went to a case which was about war crimes in Ethiopia in the 1970s. There's the accused is present, but also the victims, or some of the victims, actually were in the courtroom themselves, in the same space. There's no glass ceiling or no shield between them. And they are allowed in the Dutch court system to stand up and address the chamber, but also the accused, and also ask the accused questions. So here, perhaps, there is the possibility of a relationship or an interaction between victim and perpetrator on the one hand, but of course also the empowerment to the victim to finally raise their voice. But then what you also see, and I find this very interesting, is that not all these victims have the same expectation, right? So during this trial, I sat next to a lady who was carrying a Bible with her and writing notes in it, and basically her aim was to forgive the perpetrator or the accused and give him the Bible after he was sentenced to life imprisonment. But then another guy who was also a victim basically was sort of disappointed that the Netherlands doesn't have the death penalty, right? So the expectations and wishes for what justice seeks to accomplish are so divergent. So I think it's so incredibly impossible to just have this generic victim in law, and I don't think law is capable to address all the issues that come with victimhood. I mean, it's more for psychologists and sociologists, but not for lawyers. Lawyers are also not trained to do so, right? Okay, that's basically what I wanted to say.
Thank you so much, Ty. Sarah, please, your thoughts.
Yeah, thank you, Thais. I think you're really bringing to the forefront where I would go with this question too. So the question that was put to us was, can we deliver justice to victims, right? And we sort of see that kind of shorthand, I think, operating a lot in international criminal justice circles. Ask that question to an anthropologist and you get this kind of answer. Who's the we? What is delivering? And then what is justice, right? And then who are the victims, right? That's what we've been talking about. And so I think my first response to that question would be to sort of follow Thijs and to also borrow some language from colleagues, Sarah Kendall, and I believe Sarah Nowen, who called for humility, who basically say we need to really be a lot more humble in the kinds of language that is being used and the kinds of possibilities that we imagine for international law or international criminal justice, right? So the idea that justice is something that can be packaged into units and be sent and be delivered is I think a powerful imagery that is sort of discursively being deployed, but that we know is impossible. Right, it's quite impossible to actually achieve, and I think in part this is part of what sort of the bureaucratic form, the legal form, but maybe the bureaucratic form largely does is sort of pulling social events into its own logics, right? And I think there's a fundamental impossibility there when we look at international law. And this morning I was listening to a podcast and it was this debate between an expert on reparations and someone who works at the ICC. And the trust fund officer from the ICC was saying, we have done so much work. We have achieved 50,000 surgeries for victims in Uganda. And so, of course, 50,000 surgeries is a huge logistic endeavor. And I'm sure that the recipients of those surgeries had some of their pain or some of their injuries or their wounds repaired. But at the same time, if we shift our gaze, we see how that is just such a small thing, right, in the smaller landscape. And so I was really struck by that the kind of fundamental impossibility of scale here to really think about, to really capture and to think that you can remedy harm and that you can never fully acknowledge it.
Let me. I think Thijs's examples of
Alfonso,
different. Yes.
Alfonso, sorry. I think you caught Sarah. Sarah, are you done? Okay. Okay.
Yes,
Thanks,
Alfonso.
Done. Okay, Alfonso, please proceed, please.
Yeah. I think Thijs's example of how victims in this similar situation expressed different expectations of justice, I would say. And Sarah's reminder of humility comes at the heart of, I think, what we needed to be talking about. When we say justice, it is actually an assumption that we understand what we are talking about the same way the victims understand it. And Thijs's example reminded me of a case when I met one victim, and this victim, was having a candid conversation with me and said, "Look, the perpetrator pleaded guilty, received the sentence that the law provides, but every time I meet him, he doesn't tell me why he killed my family when we were friends." So for him, what is more important is to understand why his friend did what he did. So it is not much more about, yes, it is probably also important that he agrees that he committed these crimes, that he was punished. But to him, the fact that he could meet the perpetrator on the road and the perpetrator looks the other way, was more troubling to him than the fact that this person was punished. So my view has been that international law and those that practice in international law and the international justice generate the specific criminal justice. In this case, it becomes much easier for us to talk things in totalities. You know, this group has received the justice, but this group has not received the justice. Of course, this goes contrary to the idea of what we were expecting of human rights, which is individual, individual rights that have been directly affected, because within the totality, the totality has to come from the singulars, the individual. You cannot have many when you don't have specific individuals that make us that totality. So the question is, to what extent do you attempt to satisfy the individuals that make up the corrective to be able to say that I have delivered the justice to this corrective group? And for us, since the details are too graphic for us to bear, it becomes easier to just remain superficial and say we have provided the treatment, we have built some hospitals or healthcare centers and those kind of general support that we can provide to communities, because we know for sure that we can't deliver. And I say deliver with reservations following what Salah has just said, that we cannot do much to the victims. We can only, and this is my view, we can only as a society, and when I say the society, I'm talking about those of us who have a dominant voice within the society, we can do much by deciding on what kind of the situation you want to live with after the commission of these crimes, so that we move forward as a society. I stop there.
Thank you, Alfonso, for your insightful contribution about that. I'm looking at time now. It's 1:42. We have like roughly less than 15 minutes to wrap up this amazing Salon. I want to ask the questions, and I want us to, again, it's going to be a reflective, I want this kind of reflective engagement that we've had so far, and also more or less to deconstruct some of this concept which we've tried to do. There are no easy answers to any of the questions that we're engaging or having conversations around. They're very complex. The answers are very multifaceted, and we've identified that. But one of the things that is coming out, one of the running things that is coming out of everyone discussion or conversation is the issue of reparation, what's considered to reparation, what is meaningful around the concept of reparation. We could hear Alfonso say that no matter the kind of justice that is delivered to victim of crime, someone might still struggle with the sense of closure, particularly when you see your friend that killed someone close to you, and that person is looking elsewhere. And it's this time around, what I would call the relationship aspect of justice is not delivered, where the person didn't come and say, "Oh, hey, I'm sorry, I committed this heinous crime. I'm sorry about it. It's because of the propaganda," or whatever. Anyway, or we find where the communities in northern Uganda, where I spend a lot of time, researching around this issue, says, "Oh no, we want individual reparation. We don't want communal reparation. We don't have collective reparation. We want something that's unique." And then there's this concept where the International Criminal Justice is saying, "Hey, we don't have the resources to give individual reparation to people," or Sarah's idea of a doctor that reparation that, they provided surgery to 50,000 people, and at the end of the day, they say, "Well, it's good, but it's not good enough." Or the fact that even within a subset of people, I think myself, Kamari, and myself and other people from UBC, we did I think, oh, sorry, it was one of our classes that we taught that we invited someone to come and guest speak, and the person was talking about what people really want. It differs. Some want loss of land, they want access to land so that they can be self-sustained, they can farm by themselves. So no matter how much money they give them from the ICC, it wouldn't give them that sense of justice that because they've been uprooted from their location to somewhere else. So those contestation around reparation, what is meaningful, things that we struggle with within the international criminal law regime. In 2 minutes or thereabout each speakers, I want to ask you this reflective question, which is that how do you think restitution or reparation can be shaped and newly conceived? In light of all this contestation, all these differences, need, whatever. How do you think it can be reshaped? How do you think it can be reconceived to deliver meaningful justice across board, and not just to fill a checkbox at the ICC took it, we delivered reparation to 10,000 people. I would like a reflection on that, please.
Let me maybe jump. I guess I agree. I like the fact that many of us now have pointed to the fact that, many studies tell us that victims are not kind of a homogeneous kind of group with the same needs and same kind of desires. Research shows that, yeah, indeed, many different victims in many different contexts want many different things, and that's very important. I guess with all of what was said by Sarah and others about the need for humility and the rest, part of dealing or responding to victimization, if you will, what needs to be taken care of more than anything else is developing the ability to genuinely listen to victims, whoever the victim is. And then only then can you define what that victim needs or wants. I have always the impression, at least dealing with many different situations intimately where international crimes have been committed, that victims are quite often told what their needs are. There is this victims' rights industry which more or less dictates the narratives about victimhood. And many victims then really end up fitting within that kind of frames. And I guess it should be the other way around. There is a need for a genuine listening to victims in their plurality, in their totality, in their, if you will, conflicting, sometimes clashing voices. And then only then can you deal with them. And victimological theory always tells us that most of the time, some victims don't need much from you. Whoever is doing the responding. Probably some victims just want to be listened to. And that having a voice, it's not necessarily the house we built or the bodies or the hospitals and so on. Precisely that materialization of victimhood is part of the problem of instrumentalization of victims. Some victims indeed do need that, and international processes or institutions like ICCs providing that is a positive thing. Definitely, we shouldn't remain only in the negative. But that being said, there are many victims who don't want necessarily that, but only want recognition of their victimhood and probably specific forms of symbolic reparations, which can sometimes only be about recognition. I don't think that there are many people necessarily who expect billions of reparations from Belgium about the colonial past, but many would want Belgium at least to tell what different nasty things they did in A, B, C, D. And maybe some will want money, but not necessarily the money, and so on. And the same kind of go in different kind of context of conflicts. Genuine listening, genuine kind of understanding of what an individual victim needs or does not need, and then responding accordingly. Back to you.
Thank you so much. Sarah, Alfonso, Ty, in 2 minutes, 2 minutes each, please. I'm looking at time. 2 minutes each. Okay, I see Ty, hands up. Okay.
I'll try to do it in 2 minutes. I think the question of reparations, we also have to, I think, like Felix already started in the beginning, is to trace the concept back in history. It's a very convoluted concept. The first time reparations were paid was by Haiti to France for basically buying its independence, right? So reparations basically started as an illiberal form of transitional justice. The same thing was done for slavery. In the Dutch colonies, when slavery was abolished, slaves or people who were made slaves still had to work for 10 years to pay up the debt. There was a reparation to the perpetrator. I think reparations to victims is basically something that started in the early 1900s. It's a new concept and it's continuously changing. And I think what we see nowadays is reparations are perhaps not so even much about getting justice in the criminal sense or the civil law sense, but it's more about social justice or economical justice or political justice, historical justice, perhaps restoration of some dignity or giving back people their self-confidence and restore their sense of humanity. So I think the concept of reparation in itself is already so transitional that actually it's really difficult to find a proper solution as to what to give a certain category of victims in terms of reparation. And I think the same thing can be said for reconciliation. But a last point I want to make is that often still courts, what they do is compensate. So they come up with a form of monetary reparation, which sometimes is incredibly odd. And I think Sarah already mentioned it. We had a case in the Netherlands where basically the Dutch courts calculated to what type of percentage the Dutch were liable for the genocide in Srebrenica. And I think it was like 15%. And then they made the calculation of that 15% and had to divide it to, I don't know, a percentage of the victims who were then suffering harm, and it becomes ridiculous. And perhaps I like to end my my rant with the word ridiculous.
Thanks so much. Thanks so much, Ty. Sarah, Alfonso. Okay, this is Alfonso.
Yeah,
Please go ahead.
Yes, let me. Oh, I mean, I always feel disappointed when we have a conversation and we still end the way we started. And this is exactly the same situation. Even those that are doing their best to think that they are contributing anything meaningful to victims are going through. Because the reason I'm saying this is that I remember when we were drafting the forms for victims' participation. The first draft had, I think, I don't know how many, 20 pages or
17 pages.
Yeah. And then they realized that that was not going to work. Then it was cut down to I don't know how many pages. And the expectation was that if we were going to have what Felix was talking about, the possibility of listening to victims. But who is ready to listen to those horrible situations that victims went through? Let us be honest. I worked in Gachacha. Every day we would receive, each individual would receive, I think, over 100 calls. And I'm telling you, I have always said that working in Gachacha was my best experience in my working life experience, but it was also the most graphic and the horrible situation you had to go through, because you listen the details of harm, the details of expectations of victims, and at the end of the day, you like, this is turning me into something else that I wasn't expected it to turn into. So yes, we can say victims need to be heard. Yes, we can say we can, whether you talk of needs, and in this case, you see globally what are the needs, or you talking about victims, what they are entitled to, as in the terms of rights. And I think the safest way to go is, because victimization happens in a society, and that society deserve also justice, but also deserve to continue to exist. And the victims also want to continue in that society. So that the responses to victims' needs or rights in that particular situation where you are able to say you can monetize the harm that was suffered will depend on the context in which the harm occurred. The needs of victims in Rwanda will not be the same needs of victims in Syria, for example. Even if both, and I don't know how really to put it, I will simply end by saying that reparation also needs to be contextualized based on the society, and that reparation should be given with the intention to help the society move forward. I submit.
Thanks so much, Amfoso. Sarah, in 2 minutes,
Yes.
Your thoughts on reconceptualizing reparation.
Thank you. Thanks, Alphonse. I think your words of caution and also your frustration are heard, right? How do we keep ending up where we left off? I think part of what you're helping us see, or what you're trying to prompt us to think about, are conditions of life after the events that are being adjudicated and after the events that become the substance of international criminal law or truth commissions or any form of transition. So I think that keeping that focus on conditions of life and livability, I think, should be central. And then that's, again, I would echo a kind of humility, particularly for the organizations and the implementing partners. And I'm purposefully using that language because it sort of speaks to the industry of the ways in which people are going in, organizations are going in, they're going in with project proposals, they are going in with budgets, they have to report to donors at the end of the year. And so that means that we're back to that idea of deliverables, that we're back to that idea of units that you can implement and give. So I think a kind of humility and a kind of broader view to thinking about what is the world we want to live in? What is the society we want to live in? What are the conditions of life that are necessary? What are the conditions that are necessary to thrive, right, as humans, I think should remain a central focus. And in that vein, I've been reading a little bit about reparations orders in the Katanga case. And what I thought was quite interesting there is that on the one hand, individual victims are getting $250 US individually. And then there is another option where you can also elect for collective reparations. And the overwhelming majority of victims have said, we want housing and we want income generation. And so I think that idea of just people trying to live, I think, should really be central to the work here.
Thank you so much, everyone, for your time, for your insightful contribution and stimulating and rich ideas around the complexity of victimhood, defining who is a victim across different jurisdictions, across temporal timelines or temporal limits, across also the contested nature of what, how we can evolve the discussion around women, victims of women to non-women, and also things or categories that doesn't fit within the ideal victim category that we have so much used to. So just once again, this is almost 2 p.m. Once again, I want to thank you for your critical insights, your suggestions, your questions, your frustration, your making an attempt to engage with this problematic discourse, which we all know it's not simple white and black. As international law scholars tend to tell us that in terms of victims and perpetrators, just black and white, victims there, perpetrators there, and they did not meet in between. And also we want to thank the Center for Criminology and Social Legal Studies at the University of Toronto for providing this platform and also this opportunity for us to have this kind of meaningful conversation. We want to thank everyone for your participation, for those that participated via YouTube for your insightful contributions, questions which we tried to interrogate in our answers, because we could see some of the questions and all of us were able to engage with it in one way or the other. So your feedbacks were very, 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 very important, very helpful to situating this conversation. And also for everyone, both within this conversation, this Salon, and also those viewing us, if you need more information about the Salon series or the summer school, upcoming summer school in Rwanda, please visit the website listed in the event description in the flyer, and also you can find it on YouTube. Everything is there. Like I said at the opening of this Salon, this is the final one. We've had 3 before. This is the 4th and concluded one in the Critical International Law Salon series. And if you have missed it or you would like to rewatch the first, the earlier, the 1st, 2nd, and 3rd Salon, please go to the Transnational Justice Project YouTube page, and you can search it out, or you can look at the event description. You'll find the link to it, and those are meaningful encounters, engagement, and conversations around different aspects of international justice, including in international human rights regime. Again, thanks so much, everyone. Thanks so much. Merci beaucoup, and do have a good day.